Hey, good evening, everyone. Thanks for joining. My name's David Bartholomew, he, him, his pronouns, and I am the Homelessness Prevention Program Director at Pisgah Legal Services. We focus on eviction diversion and protecting tenants' rights in court. Happy to talk to you a little bit today about landlord-tenant law in general. Um, and I want to start by just letting everyone know I'll be taking questions at the end, but I can't answer questions that are too specific in nature. I won't be trying to form any attorney-client privileges or relationships here. If you do have a question, please try to keep it general. An example of that would be like, I instead of saying I live in apartment 402 at this address, and the landlord is this person's name, keep it much more general than that. And I may be able to provide information and answer the question. But I won't be agreeing to represent anybody today or forming any kind of, uh, even an advisory relationship with anybody on the call. So that said, if you want to apply for Pisgah Legal Services, you should. Our website is pisgahlegal.org. You can apply online there. We have some eligibility criteria, but we are open. We are taking cases. If you'd rather not apply online, you can come to our office if you're in Nashville on Charlotte Street and apply in person, or you can also contact us at our by phone, and I'll put all that information in the chat when I'm done talking. So the first thing I want to start off by saying is, everything has changed in our community practically. It's been a devastating time for all of us, and we see on a daily basis how different things are than they were a month ago. And that said, the Chapter 42, which is North Carolina's landlord tenant law, has not been amended. You know, Nothing about the legal authority for evicting someone or that tenants can rely on for rights enforced by the state. None of that has changed. There is a bill um, that's being put in front of the legislature to change a few things for Western North Carolina counties. And I'm hopeful that there will be a moratorium and allow, our region to have some time to recover and not displace more people. The natural disaster has done a good job of displacing so many of us, and it is my hope that we will not do that when we have a choice not to. But right now, we have no idea if that will pass. We don't have anything from the governor or the state Supreme Court that has changed tenants' rights in Western North Carolina. So I'm going to focus on a few things that I think a lot of people have questions about. But it's important to note that this is, this is how the law was on September 24th, and it's how the law is today. I think the most important thing for our community to know, and what I worry about most right now, is that there's going to be self-help evictions. And the first thing I want to emphasize is that if you're a tenant in North Carolina, you have a right to the court process. You cannot be evicted by any other way. Landlords must file summary ejectment. That's what evictions are called in North Carolina. And that would entitle you to, being served, either your property being served or you personally being served with court process, the accusations that have been made by the landlord, and an opportunity to go to court, bring an attorney if you can get one, and defend yourself. And that whole process does take some time. Our courts are mostly open. There's some courts that are not open north of Buncombe County yet, but mostly they are open. But the courts are moving slower than they were before. There's a backup from being closed for several weeks. And in some cases, clerks and judges are trying not to move things like evictions at the rate they were moving before. But that's, that depends. And they certainly could move at the speed they were moving before. So if you hear of a landlord telling a tenant that they have to get out, or they're going to change the locks, or that the recently returned utilities are going to be cut, or that they're going to call, the police and make them put your stuff out on the lawn, that's an illegal eviction. And Pisgah Legal wants to help defend against those. The landlords must go through the court process, and that hasn't changed. And we worry about that in times of disaster, that people think they have to to go. And the truth is that they can't be evicted any other way but through summary ejectment. The next thing I want to talk about briefly is the landlord's duty to repair. It's true that under North Carolina law, certain things cannot be waived or contracted around. So a landlord can't decide that by putting in a lease or telling a tenant that they have no duties to make repairs for certain things. And generally, what we call fit and habitable, that's what the statute uses, requires that there be running potable water and that there be power. And so the landlord renting a place that doesn't have those things could potentially be liable for breaching the duty of warranty of habitability. Now, that sounds pretty good, and it is in there. We don't know how courts will interpret it when the landlord really isn't responsible for those things. But it's, like I said before at the beginning, chapter 42 is the same. This is 4242, and landlords still have that duty. Nothing has changed about that. The problem, and the next thing I want to talk about, which is directly related to this, is that duty that the landlord has is separate and coexisting to the tenant's duty to pay rent. And so, just like nothing's changed for the landlord's duty to repair, the tenant's duty to pay rent has also not changed. And because these duties are not reciprocal and they run together, you could have a claim against your landlord for not repairing or not providing a habitable dwelling, but they could also have a claim against you for not paying a rent if you just decided not to pay rent. The real way to win that case would be to sue the landlord for rent abatement and argue that they have breached their duties and prove by a preponderance of the evidence to a magistrate or district court judge that the landlord has not kept the place habitable. And you could get a money judgment against them. And in the same case, if you had failed to pay rent, you could be evicted and lose possession of the place because both parties would have breached their duties. That doesn't make a lot of practical sense, but that's the way the law works here. And so we have to advise tenants that if they're able to pay rent, they should, in order to avoid a summary ejectment for non-payment of rent or breach of the lease for non-paying rent. So there is a provision in Chapter 42 about when a home is seriously damaged and what rights a tenant might have to get out of a lease or a landlord to get out of a lease. And this is Chapter 42:12, and it gives a tenant a chance to cancel a lease within 10 days of the damage. And you have to notify your landlord in writing within 10 days of the damage that you intend to terminate the lease under 42:12. 10 days has obviously run since then. We don't have case law on this. 42:12 is not something that has been litigated a lot. We don't know how courts will interpret whether the 10 days runs from actual notice or from the disaster date, or if it continues to run as long as the place has damage. It's really something that we can't guess on. We know that that statute exists and it might provide a way to get out of a lease if you wanted to. The other problem with that is a lot of people, of course, don't have a place to go. Like just getting out of your lease isn't something that, everyone's interested in. Certainly if you've moved already and you have, 10 months left on your lease, this might be something that you'd want to consider. But you need to consider the options carefully, and you need to think about what the the uncertainty and how that will be interpreted has to be factored into any decision I think a tenant's going to make about just terminating your lease. The landlords cannot just cancel a lease under 42:12, and so it doesn't quite give them the same kind of power. And so that's one area where Chapter 42 gives tenants a little bit of power. But again, terminating a lease and getting out of a lease, that's not what most of us are struggling with here. It's about wanting to, not really being able to afford rent, not thinking that it's just to pay full rent for a place that is lacking water and power, and having landlords who are demanding that and threatening eviction for it. But I wanted to talk about that just a little bit, because there's a lot of information out there about cancel your lease within 10 days. And, I think it's true, it exists, but we don't know exactly how that's going to play out. The last thing I'll talk about, and then I'll be happy to answer questions both about the summary ejectment process and what we've heard that's going on in Buncombe County and other counties around us. But in general, your landlord is not responsible for damage to your personal property. If you were fortunate enough to have renters insurance, you can contact them. They might be responsible for that. And FEMA is supposed to come in with damage to personal property from floods and natural disasters. That's not across the board. If you can show the landlord knew about the risk and was negligent and not doing anything about it, you might be able to overcome the general idea that landlord's not responsible for damage to your personal belongings. But it's going to be, you're going to have the burden of proof there. So I've been talking for about 15 minutes, and I want to hear what questions you all have. I hope some of that has been helpful. Again, just a reminder about the questions. Leave out personal information. I'll just be trying to give you information and answer general questions, but I won't be able to answer them if they're too specific in nature.
I have a quick question. I'm wondering, I'm one of those that wants to break my lease. I haven't officially put it in writing that I wanted to because I'm not really sure how that's going to turn out. And I wanted to get some more understanding that there was no damage to my house other than the non-potable water source. Do you think I can make that happen to break my lease?
Yeah, it's a good question. I think if you have a couple of things to overcome, the first thing I'll say is that it would appear with no water, no potable water, that the warranty of habitability may have been breached by a landlord. And so you might have a claim to, get rent abatement, or you might want to talk to your landlord about trying to get out of a lease. Whether or not that not having potable water is damaged to the point that it's not habitable, such that you could use 4212 to terminate your lease, is an open question. I can only say maybe. Possibly if you got to court on that, you might win. Is it within 10 days now? We're, 28 days from the storm, 20, I don't know exactly, 20 some days from the storm. I don't know. Unfortunately, it depends. But I think in that situation, you can, mention that and try to negotiate with your landlord to mutually rescind or terminate a lease. And I think that's a lot of times what we're advising people to try first. And then if you have to fight it, I think it depends on what, how long is left on your lease. What are the consequences if you leave? Something you'd really like to talk about the personal details of your situation with an attorney. And we are trying to provide advice to individuals in those situations. So might be good to contact Pisgah Legal.
Thank you so much.
Okay, I see Christopher with a question next.
Thank you. My question regards mold damage. We have a large crack in our ceiling, exposing drywall, and we have 3 spots in our house where mold is growing through the ceiling. So you can see it in tiny spots, with your own eye. My concern is that there is large amounts of mold in the attic or on the other side of the ceiling. Where does mold damage fall into fit and habitable?
Yeah. So mold is not one of those things that is when I was talking about things that the landlord can't waive, they're basic safety things like heat, water, power, things like that. Mold is very complicated. It's a difficult situation. And unfortunately, you've already heard me say it depends once, but that's the lawyer's favorite answer just because it just does. And when you're trying to advise on what's going to happen in a court of law, you need to know all the details. So pictures of it, testing of the mold. What I'll say that I really haven't said yet that I think is super important is that if you have conditions issues, whatever they are, mold being one of them, you need to go ahead and put it in writing to your landlord immediately. date and sign this letter, send a text message and take screenshots. Don't just call the person, call the landlord and request the repairs. A liability for the landlord starts when they are on notice. And even though it may be obvious that they know about it, you need to prove in court that they did. So with the situation where you've got molds, you can try to find out more about it. If it's mold coming from the ceiling or behind the walls, as a general rule, that's probably not the fault of the tenant. If it's mold under a leaky faucet or sink or something, maybe depends on when you reported the leak. But mold cases can be difficult. They can turn into personal injury cases. There are all different kinds of mold. Some of them are really dangerous. Some of them are not so dangerous, but just gross. Either way, the landlord should have a responsibility to do something about that. And I would recommend going ahead and making sure you have evidence of that. They have a reasonable amount of time to make repairs. That's what the law says. What that is, I think, probably is dependent on the circumstances. And on the 23rd of October, 2024, it's probably reasonable for them to take a little longer to make repairs. But it's a standard, not a bright line rule. So hopefully that's helpful.
The chat is bumping right now. Thank you for that answer on mold. I am going to go through a couple of these. I have a slightly unique question. Can they evict us if we speak out on how a landlord has handled a situation, i.e. leaving public reviews, speaking to the media /radio/news?
Yeah. So I would say the answer to that question is no. I try not to say it depends.
Totally.
So there are four reasons a landlord can evict in North Carolina using summary ejectment. Number one is non-payment of rent, and that is a statutorily created, and it's really for where there's oral leases or that's not covered in the lease for some reason, like the payment of rent. But it's basically what forms a tenancy, right? Is that you pay rent in exchange to stay in a place. In general, that's the basic bargain of any lease. And so you can be evicted even if you don't have a written lease, like you can be evicted for non-payment of rent. Number two is for breach of the lease. This is just breach of contract. Like you need to look at your lease. You can have an attorney review your lease, but there's an allegation that somebody has breached some part of that contract. And you can evict for that. You can evict for criminal activity. It's complicated, but the criminal activity really needs to be related to the premises. There are certain kinds of criminal activity that don't apply, and there are some that do. But it's important to know that you don't have to be convicted of a crime necessarily to be evicted for criminal activity. But in general, it has to be something related to having on the premises. But that's a complicated area where it definitely depends a whole lot. And then the last one is holdover. That's when your lease is up and they don't want to renew the lease, but you're still there. You're considered to be holding over. So when it comes to speaking out, unless you've committed a crime or you've contracted with them specifically not to talk to the media or something, the idea would be that no, you shouldn't be able to. There's also it's illegal to have a retaliatory eviction. But that's a very difficult thing to do for tenants because you have the burden of proof. And unless you have a landlord who really isn't very bright and says, I'm evicting you because of this thing you did to me, and I'm retaliating against you, and they put that in a text message, then it could be difficult to prove. Lots of times landlords don't say that. They find another reason to evict, a pretense, some other violation, or they just refuse to renew a lease, which is completely illegal in North Carolina, unless it's subsidized housing. So that's a depends answer to that question, but if you should know that practically speaking, if you speak out, it's a good thing to do. It could be good for your community. It's important for us to speak out against injustice. And at the same time, you should be aware that there's a risk. Like if you aren't doing some other part of your lease, like if you're behind in rent, it's probably more likely they will file. So it's sort of a practical versus legal situation there. there another? I have not looked at the chat yet, but I will put contact information in there, but I assume there are more questions.
I have a question.
Hold on a second, actually. We're gonna skip to this one in the chat real quick. What are the potential consequences of not paying rent if I do not have a lease with my landlord?
Well, so that's a complicated question, but if you don't have a lease, I think you probably mean a written lease. The oral leases are totally permissible in North Carolina. You can have an agreement to stay with somebody. I can say, hey, John, I'm going to rent this place for $250 a month. John says yes. I hand him $250. We have a lease.
Totally.
So it's an oral lease, and it's going to be difficult to prove what the terms are. So it's different than a written lease. But in fact, it's enforceable under North Carolina law. So if you don't pay rent and you have a lease, like you're subject to that non-payment of rents provision that I mentioned, like that's really specifically there for that situation where there's an oral lease. So the terms haven't been written down, but they, if you have given money in exchange to be able to stay somewhere, you're probably a tenant. And if you don't pay your rent, possibly you could be evicted for non-payment.
That makes sense. Okay, I'm gonna skip ahead to this question because I've seen it asked in a lot of places. Do we have a right to request landlords to reduce rent? And how would you recommend making that request?
Yeah, that's a good question. I think the first step is to try to see if you have a landlord that's willing to work with you on this. Pisgah tends to see some of the bad actors, like we get calls when there's ridiculousness going on, but there are some landlords who are, recognizing that FEMA money helps homeowners more than it does renters, and that there will be money coming to them, but it's going to take time, and they're willing to waive rent. There are also landlords who are smaller and not sure, but they're working with tenants to try to reduce and split. So yes, I think that's a good idea. I think trying to talk to your landlord first, explain the situation, explain the increased cost, last block of income. If you've applied for unemployment, that takes several weeks. If you've applied for FEMA, it can go faster than that, but it's also can be a pain. There will be rental assistance, I assume. The city council last night in Asheville approved some funding that will go towards rental assistance. I expect more from HUD and hopefully other sources of rental assistance, maybe even the state. Never want to count on that, but you never know. And so I think it's important to talk to your landlord to explain the situation and see, there are landlords who are just moving quickly and, not very considerate. And that makes it really difficult to try to start being reasonable. But I think that's always advisable at the start to see if you can work something out.
That makes sense. Okay. I'm just gonna move on to this question from Susan here. If my home is uninhabitable, yellow tag from the county, can my landlord require me to pay rent? My landlord has not fixed anything from the flood. He's not supplied me with well water testing. I paid because I was worried I had no legal representation.
Yeah. So I'll go back to one of the things I wanted to make clear that's very frustrating. Outside of letting people know they have a right to legal summary ejectment process, because I think that's my biggest concern, is that people are going to get evicted without any chance to raise arguments or have the process of the court summary ejectment. But other than that, things I want people to know is it may be that your landlord is liable for rent abatement for renting a place that didn't have water or power, maybe still does not. They cannot waive the duty to make those repairs. And you still have a duty to pay rent at the same time, even though they are not providing you with a habitable place. It does not mean you can stop paying rent. That is inaccurate. You can sue them for rent abatement and then get a judgment for them against money. And then maybe you cannot pay them rent in the future, or that you would get a credit towards rent from the money judgment that you got in court. But until you have that, you have a duty to pay rent under the lease too. And even if you won your case against the landlord, if you also failed to pay rent, they might win that part of it and could take possession of the property back. I do not make the rules, just telling you what they are.
Thank you for that. I want to give Spike a chance to ask some questions on behalf of some people that reached out to the tenants union. They weren't able to attend, but they are going to view this later. Spike, are you good to be able to do that right now?
Yes. So, I have a question speaking from a third party perspective. I work at a nonprofit. We have clients whose homes are undergoing repairs. If we seek funds to aid in repairs for our clients, is there any way to reassure the landlord won't turn around and terminate their lease, kick them out in the future?
Well, I would just say, if you've got a lease for 12 months, then they would have to prove that breached the lease or have good cause to do so to evict you. If your lease is running out, then, that is a concern. Unfortunately, in North Carolina, landlords are under no requirement to renew a lease. We saw this a lot during COVID. There was a moratorium in place and there were restrictions on evictions. But there was, once a lease was up, they were not forced to renew the lease or allow the tenant to stay there. And that's still the case in North Carolina law. They don't have to renew it. So it can be a tough situation depending on how much time you have that you kind of have to think about. That's different in subsidized housing. In subsidized housing, for the most part, there's so many kinds. So I'll just say most subsidized housing, you have to have good cause to not renew a lease. So it's essentially like a breach, like you have to breach some general provision of a lease. A little more complicated than that, but basically.
Thanks for that, David. Another one I have for you is how long is my landlord allowed to take an order to make my home livable for me?
How long does a landlord have to do it to make it or to make the repairs? Is that the question?
Yeah, how long is my
Yeah.
landlord allowed to take
Yeah.
yeah.
Unfortunately, that's not well defined. It's defined as a reasonable amount of time. So you would in court, you would, use other factors to argue that's not reasonable. It would start from you requesting, the repairs be made and telling them, depending on what it is. And then I think at some point you'd ask the landlord what's going on and try to get some assurances about who they've contacted and what they've actually done to make those repairs. Uh, that can help you show that it was not reasonable if you can get a landlord to say he hasn't called somebody or, and at some point we might advise calling to get estimates themselves if the tenant's willing to do that. It's not really their responsibility, but it can help show that there's an unreasonable uh, activity going on from the landlord and that the delay is unreasonable. But unfortunately, can't say like, 10 days, 3 weeks. Like, I do think, because it's a standard, judges would look at Western North Carolina right now and, how difficult it is to get materials and people to make repairs, that it would be longer than normal. But unfortunately, all the details of that situation are going to matter a lot.
And along the lines of like the landlord taking into account, another question that we got was, what happens if my home is uninhabitable and I have a lease that my landlord isn't letting me get out of?
Yeah. So if it's really uninhabitable and it's been damaged by the hurricane, you might be able to use that provision, 4212. Never really seen courts interpret that, but you could try to terminate your lease and tell your landlord that you want to terminate your lease under 4212. Argue you'd have to show that it was destroyed or really damaged, and so it's not habitable. And you'd also have to show that you're doing it 10 days in writing after you've noticed the damage, or I don't know. I think arguably you could still be doing that, but I'm not sure if that 10 days would be from the 25th of September or not. So arguably it should continue as long as it is still uninhabitable. But that's not something we've seen a whole lot of. I think trying to talk to your landlord about getting out of the lease is good. And if they refuse to let you out of the lease, then you need to look at what happens for early termination, if that's in the lease, and kind of consider your options and weigh it out, because you're going to have some uncertainty in how exactly it's going to play out. That's a question that really you want to talk to an attorney through and give all the details. So if you're in that situation, I recommend calling.
The next one I have is kind of a two-parter. What happens to my credit reporting if my landlord files an eviction, but we come to an agreement after? And how do I appeal an eviction?
Two separate questions.
Mhm.
So first one is, well, I talked to state senator about this yesterday. One of the frustrating things about North Carolina law, we've been asking for this for a long time, is that they create an eviction record and expunction opportunities for people. And that's because a lot of times people do work it out and they do end up satisfying the judgment or moving out. And those cases get dismissed, yet property management companies are permitted to search for records that only have filings. So that's very disappointing because the filing means nothing. It just means that somebody has taken out, sued you for summary ejectment. It doesn't mean that they had good cause, that they had any case at all, that they won the case. So recommend trying to get a copy of the dismissal if that's what happened, or a letter, something that evidences the agreement would be good to show to credit report agencies. That puts you in a difficult position because if you've ever tried to deal with them, again, you have the burden to show that you don't owe the money if it's already being reported. So hopefully that's helpful there. I do think that the state has come closer to dealing with that. A lot of states have an ability to get rid of an eviction that's been settled. It's crazy. But it affects a lot of people. It disproportionately affects people of color. And it makes no sense. The other question was about how to appeal an eviction. I think, appealing an eviction is if you lose in small claims court, which is where most evictions take place, summary ejectments, you can appeal to district court. You have 10 days under normal circumstances. The appeal deadlines during the pandemic, during the natural disaster, have been extended in most of our counties. In Buncombe County, it's the 28th of October, so you can still appeal an eviction from the 25th on, I think. And you file paperwork with the district court. Pisgah can sometimes assist with that. You do have to pay rent bond into the court. It's not free to appeal, and you have to have, some basis for your appeal. But doing that will get you a new case in district court.
Awesome. Thanks, David. And just a reminder to folks that we'll be uploading this conversation on our YouTube page through Pansy. The last question I have in relation to the tenant union, as well as some of the questions being asked in the chat, is do I have to pay rent if I don't have water and/or if my utilities were interrupted?
Yeah. So this one is a question I've tried to answer, but the truth is that if you don't pay your rent, then you can be taken to court for non-payment of rent, regardless of whether the landlord is also liable for failure to make repairs. So if you decide not to pay rent, or if you're unable to pay rent, you should know that you are potentially at risk for losing a summary ejectment for non-payment. And that's absurd. You might win money back from the landlord, but lose possession of the property. I've seen judgments where somebody loses, they win thousands of dollars for the landlord for their failures to make repairs and provide a habitable place, but they also lost on possession of the property for a failure to pay rent. So they don't owe any money to the landlord, but they can no longer stay in the place. Possession has been returned to the landlord. So it's a depends question for sure.
And continuing in the realm of rent, there were some questions in the chat about inquiring for a rent discount to the landlord, and how would you recommend them going about that?
Yeah, I mean, hopefully you have a decent relationship with the landlord, and hopefully you can do something that's in text message or an email, so there's evidence of it. I think some landlords are gonna, listen to your situation and be willing to work with you. To me, it's important to mention when you might be able to pay some of it. Again, you know, uh, if you're in a situation where you lost income for 3 or 4 weeks, you haven't returned to work yet, but you've got a start date, you've applied for unemployment, you've got pending FEMA applications. These are things that I think a landlord would, you know, be interested in hearing, that the situation is going to change. It's not going to go on. Um, so, but I think the relationship you already have with a landlord, who is this landlord? Are they a big business? Can you even reach them? Do they have some property manager next door, or is it somebody who lives in Florida? It's a tough situation just to answer that for everyone. But yeah, I think trying to explain to your landlord what your situation is and when you're gonna be able to pay rent again, if that's something you can do, or if you're looking to move, how long do you need?
Awesome. I think we have like time for like a couple more questions, if that feels good with you, David.
Yeah.
Okay.
In line with the property management companies, I have this one from Paul here. If the property management company has offered a rent abatement value for 18 days and tenants pay the October rent to avoid being delinquent, does that mean that we cannot still argue for or receive an additional abatement based on continued lack of potable water? Potable water.
To do it, but I think it just depends on what's in that agreement. I mean, if the agreement, lots of times when you waive or you sign an onto additional terms, there's language in there that settles all existing claims, but I don't know what was in that particular agreement. So I think, unfortunately, you just need to have somebody review that for the specifics.
Hi, David. Oh, sorry.
You're go for it.
So I have a question. I have lungs that are immunocompromised. I have reached
So
out
I'm
to
going to
an
stop you
attorney
now. I'm going to stop you now.
at your law firm. No. That's okay. I'm just saying that. I've reached out to an attorney at your law firm. My question is,
Yeah, so I'm just going to pause there. So if you start giving me individual information about your case, I just won't be able to answer it. As I explained at the beginning, I'm here to provide information and try to help everyone better understand the rights as a tenant. I'm not here to advise your individual situation or form an attorney-client relationship with anybody. So if you start giving me too many details about your situation, and I know that's frustrating because I say it depends a lot, but you're just going to need to contact Pisgah Legal. This is not the proper forum for me to give specific advice about a specific situation.
I can try to reframe her question because I saw it in the chat in more of an indirect way. If you could just share some information about like what kind of resources may be available for someone who is immunocompromised experiencing mold. I've seen a lot of questions about mold. So maybe just a little bit of information around mold damage to the house and people's right to get that treated, or like what kind of access to resource there is there.
Yeah, mold cases are incredibly difficult because they're complex, and there's an argument from the very beginning about who's at fault. Now, we're seeing a lot of mold cases because of all the moisture and the water that got in places where it's not supposed to go. These are most likely the responsibility of a landlord. Again, you need all the details. If you're going to win a mold case, you need to explore all of that. How did this mold start? Where is it? What's being done about it? The first thing you can do is make sure you've proven that you've let your landlord know that you have this issue and that you need to treat it, and see what happens. Hopefully they come out and try to remedy the situation. And then if you're going to win the case, you need to show that they didn't in a reasonable amount of time do anything. And then the damages are very dependent on what kind of mold it is and how damaging it is. I think as far as if you have a disability, there can be additional protections. I'm not going to go too far into the ADA or fair housing, but it's possible that landlord would be required to make accommodations or modifications for somebody with a disability. And so that's, again, a very specific context dependent analysis about what will happen there. So I don't really want to say anything more than that. But there are additional protections for those with disabilities and people in protected classes. So mold is very difficult. It needs to start with a request to make repairs. You need to take pictures. You need to consider testing. And you need, doctor's notes and all those things that you might need for a personal injury case, that's causing the injury, that the mold is responsible for the injuries that you're suffering, not just the breach of contract, but also, what it's done to you as an individual. But it's not that simple. Mold is tough. Let's start with proving that you've requested that it be remedied and evidence that it exists.
Yeah, a lot of what we're getting is just kind of the same version of like, do I have to pay rent if my house is unlivable?
Yeah, because it's crazy. Like the answer to that outside of the law is like, no, you shouldn't. It's insane. And hopefully rental assistance is on the way. And hopefully if we can pause as a community, like we can recognize that nobody asked for this natural disaster. All of us are suffering, some obviously way more than others. And I think it's just fair to note that, tenants often do not recover like homeowners do. The whole way our disaster recovery system works, I don't think it's fair to tenants, and people of color are disproportionately tenants in our community. So there's equity issues all the way, but it's not fair. But my job here is not to tell you what's fair. It's the rules are the same as they were before. And if you don't pay rent, you have to understand that there's a risk that you could lose an eviction.
I see a hand raised from Nicole.
Hi, good afternoon. Can you hear me?
I can.
Hi, perfect. So, without giving any specific details, I was just wondering if you can advise on any particular language one could use in a lease termination letter to give them the best possible case. I mean, I know they can argue the 10-day thing, but I feel like many of us didn't have power or internet for those first 10 days and wouldn't have been able to make that contact anyway. And so I was just wondering if there's anything in specific we should reference, or if there's like a better way of putting something in a letter.
Yeah. I mean, I think it's tough because there are like other questions that would maybe change my advice on that situation. But in general, I think you can reference 4212, that your home is damaged to a point that it's not habitable, and that you are letting them know per 4212 that you intend to terminate your lease. I think that's fine as a notice, because if you end up having to go to court arguing about it, like you're going to get to fill in details about that and argue when you became aware of it, and whether the 10 days starts from the date of the hurricane, or when you got internet, or when you moved back, or like, is it still running now because you don't have potable water? I don't really know. I mean, but you'd be able to make those arguments, I think, if your letter, cited 4212 as your reason for terminating the lease.
Okay, great. Thank you so much.
All right, just trying to move on here, y'all. What is the relationship between liability of the landlord and the property manager? If I'm taking them to court, should I be naming them both, or just one or the other in the small claims suit?
Great question. Name all parties. You can always drop it against them, or you can leave it to them to get themselves removed from the lawsuit. I mean, just typically it's going to be the owner of the property, but it may be more difficult to find the owner, especially if it's a big, you could always try to look up the deed. But name them all.
Thank you. If I'm unable to pay my rent, can my landlord pull from the security deposit funds to pay themselves that rent?
Good question. Security Deposit Act has not changed either. That's another part of Chapter 42 of North Carolina Landlord Tenant Law. Security deposit is for, is to be held in a trust account by the landlord per that statute. And it has to be returned to the tenant after they have moved out. So they're allowed to hold it as long as you're still residing there. They don't have to give you back your security deposit. After you vacate and turn in your keys and deliver possession, they have 30 days to return it to you or tell you why they haven't. And if they don't tell you why they haven't in writing, then they waive their right to keep your security deposit. But one of the permissible things that they can keep a security deposit for, besides damage, is unpaid rent. So it's possible that a landlord could keep parts of your security deposit for unpaid rent, but they have to follow strictly the Security Deposit Act.
Okay, can y'all still hear me? Okay. In the case of leaving a lease, my lease was already supposed to be up at the end of November. I haven't signed a renewal yet, and they want 60-day notice to leave. Is there a way to argue for a shorter notice period given the circumstances?
So you can always negotiate. It depends on the leverage you have. If it's a bigger landlord, they may not be willing to make any amendments to the lease, but if it's a smaller landlord, you can, yeah. I mean, you're always free to negotiate. A lot of times, leases are sort of contracts of adhesion and there's not a lot of bargaining power. Like, you're trying to find a place to live in Asheville and you don't have a lot of leverage to, argue about the terms of the lease and what they should be. But you can always try that and see how it goes. And some landlords are willing to amend. And maybe you have more leverage now. I mean, I don't really know the situation. There's still not potable water in a lot of our places, but there's also less units. I imagine there's slightly less demand, but we don't know how long that will last. So
if a building is in a historic district, do landlords have any extra protections or exemptions on laws around maintaining habitability?
I honestly don't know the answer to that question. There are zoning and building code and historical preservation statutes. Like there are municipal regulations and state and federal regulations around those kinds of things. Not so sure they'd have to do with habitability and tenancy, but I don't know.
Could we pay a portion of our rent until we get a response of initial issues? From Karen, I don't.
Knowing nothing else, sue you for non-payment of rent. And at the same time, maybe it would give, if they accepted it, it might give you more time or an extra defense. But I think it's pretty risky and it depends on your situation. If you've agreed to pay $700 in rent, and it's laughable around here, and you pay $699, technically they could sue you for non-payment of rent for the dollar. So
I just want to give folks a second I think we went through the chat. If anyone has anything else that they want to bring up, or if anyone on our Instagram live has anything that they want to ask, you're welcome to raise your hand or throw it in the chat like we've been doing. Go ahead, Jonathan. Hey, Jonathan, if you want to come off mute, you can ask your question.
Sorry. Our landlord said they give us a discount, but they want to wait till we have potable water to do it. And I'm just wondering, how long do we, I don't know when that's going to be. How long do we have to wait for that?
difficult to say. I mean, it sounds like you've got a landlord who's working with you, so you could try to ask for details and try to get some more information. But I think obviously it's going to just depend on a lot of things. Um, I think a lot of people are just waiting on the assistance to be clarified and come through. Whether it's an insurance claim, a FEMA claim, unemployment, waiting on rental assistance to actually know where to go for it, uh, to get Duke Power or Spectrum. Like we're all just waiting and trying to figure out how this is going to work out for us and what's going to happen. So you can understand why somebody might be waiting. So it sounds like they're being patient, but uh, they don't have to necessarily give you a discount, though. I think a lot of people are being advised to do that on that side to avoid habitability problems, like liability for that.
Can you just speak a little bit about what rental assistance is and who might be eligible, or like some examples of what maybe already exists in that realm?
Yeah, it's a great question. So, right now you can call 211 to see if there might be rental assistance. 211 is a number the United Way puts on, and there are local people who can direct you to possible rental assistance. Right now, I think most of the assistance has gone to, FEMA, to people who really have lost, who are no longer in their places. But the community leaders are aware. I mean, we saw City Council last night approve some HUD money, from the Housing Trust Fund, and a couple of other sources that will be going towards rental assistance. I don't know how it will be distributed. I was on a call with staff talking about that very thing. They may use Dublin or ABCCM, or they may go through Buncombe County DSS. Those are all places that have provided rental assistance in the past. I think it's something to follow. You can read news about last night's city council meeting. But in the coming weeks, I assume there will be more information, and Pisgah Legal will be updating our website and social media to, make people aware of that, because it will go fast. We've seen before rental assistance, it's something we know stops evictions and homelessness, because we have stats now from the pandemic where evictions and homelessness went down, and it's directly correlated with moratoriums and rental assistance. So it's a choice our society can make. We can decide not to have these things go forward, and hopefully we will. But it does take time to set up, how rental assistance, where it's going to go, how they're going to set up the application, who's eligible. I don't have answers on that. But in general, I think it would be aimed at people who, lost income and weren't able to afford their rent because of the storm. I think that would be, at first, what the kind of assistance that's available for people.
Just giving a little pause if anyone else has anything come up. Really grateful for your time, David. Thank you for laying it all out for us. I know there's been a lot of fear and a lot of speculation. And I know that there have been landlords that have been using that speculation to, and I think just getting some clarity will provide a lot of empowerment for folks in the room. So I really appreciate that. I've learned a lot that I didn't know before.
Yeah, well, I appreciate you having me. It's normal to have questions, because the law is not really it's not really built for these kinds of situations, and it's very frustrating. But again, I think Pisgah, we will also be doing some videos. We haven't posted them yet, and I put my email and our number in the chat, and then you can also go to pisgahlegal.org and apply online for our services. So I hope people will do that if they need to, and encourage their community to do so also. Thank you for having me.
All right, y'all. Thank you for attending this session. I think we're going to stop recording here and just let folks head out.